Yes. Hello, my beautiful friends, and welcome back. I hope that your day has been absolutely outstanding. We have an amazing live stream ahead. We've got two segments to dig into. Quick preview, then we'll zoom in for further detail. But we got a nice appeal victory out of the New York case that we've covered a lot here. Remember these two knuckleheads? Judge Juan the Con Mercan and Alvin Bragg. They prosecuted President Trump using these two people as their key witnesses, Stormy Daniels and Michael Cohen. And we had a big battle about whether this court should even be hearing this case, since Alvin Bragg was calling this an election crime. And if it is an election crime, then shouldn't that be heard by a federal court? Well, Trump appealed that a couple of times and didn't get anywhere until today. And so we've got this queued up right fresh out of the oven. Second Circuit Court of Appeals remands this back down to the district court level to tell them to review their prior mistake. They didn't give Trump his due process and his due diligence in making this decision. So we'll talk all about that. We have a great stream on this one planned ahead. President Trump was also talking about this and about the pardons from Biden's auto pen and how those aren't valid either. So some justice now in the prosecutions of the president. Then we'll turn our attention over to the Charlie Kirk case, because we've got a new filing from the media, and you can see a bunch of people came out on this one. Salt Lake Tribune, the AP, Fox 13, Millard County Chronicle, Castle County Radio, everybody there, CBS, New York Times, CNN, Fox News, Law and Crime are all coming in as media intervenors to get access to this case. And for some time here, we've been hitting the alarm bell saying, why are the Zoom cameras off? We had the two hearings here on 9/29 and 10/27 where they didn't even show us Tyler Robinson. They just kept the Zoom camera off. They're like, are you there? The jail was like, yeah, he's here, pretty sure. And we got some questions about it, but then we saw that the prosecutors in Utah were wanting to appear telephonically, and both sides were playing patty cake. Both the prosecutors and the defense are saying, let's lock this whole thing down so nobody can see anything about it. Well, the media has now moved to intervene, and they said, listen, judge, like, you got to give us access to this case. So they got an 11-pager that we'll go through. We also have an order on the latest from the judge, kind of adjusting some things around, granting some motions and more. So we'll go through that. And Erica Kirk also weighed in yesterday with Jesse Waters about what she thinks should happen with the cameras in the courtroom. And so it is a beautiful day, my friends. We're very glad that you're with us. Thank you for being here. Thanks for subscribing to our channel if you haven't already done that, so that we don't miss you the next time we go live. We'd love to have you. We also want to shout out our amazing membos. We love our membos. We appreciate your membership. We had a great members only live stream this morning. So if you missed that, check that out. We talked about, well, everything else that's going on that we can't get to here. It's a lot of fun. We have an amazing community. We appreciate your support, and we'll see you on the next members only stream. We will not have an after party today. So if you're on locals, squeeze those comments in and we'll make sure we snag them. But let's get into the business on the day, because here we go. Victory for President Trump on appeal. We're coming out of the Second Circuit. And this was a big one because Trump has been fighting for this for some time. This, of course, is in the case involving the criminal prosecution brought by Alvin Bragg, this guy, who brought in the trial Michael Cohen, a convicted perjurer, to run his mouth, to talk about alleged payments to Stormy Daniels, who's also allowed to run her mouth with all her inconsistencies. And Trump said, why is this case being prosecuted by Judge Juan Mercan? Alvin Bragg is alleging that these are federal election crimes. So why are we in state court? Trump tried multiple times to do what's called remove the case from state court up into the federal courts, remove it on up. And they said no many times until, of course, today. And so let's get into the filing, because it is nice. And we're going to see what happens when this case goes back down to the district court and what she says. And this is not a victory that will dismiss the charges, but it is very curious, because if the federal courts should have had this case and Alvin Bragg prosecuted the case, well, then he prosecuted a case that he shouldn't have had. So those convictions should go bye-bye. So here you can see the case, of course, the people of the state of New York, who, as we just saw from the last election, are lunatics, but they came after President Donald Trump. We covered the case here at length. We watched the witnesses lie through their teeth, and the judges just say, that sounds good to me. Here's what the court said. All right, rewind the clock. Let's go back to March 2023. A New York State grand jury indicted President Trump. Remember those 34 counts of falsifying business records. 1 felony for an invoice, 1 felony for a check, 1 felony for writing the check in your QuickBooks ledger. Multiple times, because Cohen was getting paid on monthly basis. So he got charged. The indictment said that Trump orchestrated an illegal scheme to influence the 2016 election by directing his lawyer, Cohen, the perjurer, to pay $130,000 to film star Stormy Daniels. Remember that? She didn't want to reveal an encounter with the president, allegedly. Trump sought to remove the criminal case against him. It got brought in New York State court, so he wanted to remove it up to federal court. He said the federal law says we can do this, but the district court at the time said no. She said, sorry, you can't do that. It doesn't fall within the purview of the statute. Following a state court jury trial in Judge LaJuan Mercan's courtroom with Cohen and Stormy and the rest of them, Trump was convicted on all counts. Remember, after Trump's conviction, but before his sentencing, guess what happened? The United States Supreme Court came down and they issued their immunity decision that Judge Khan did not pause to consider. Remember, Judge Chutkan did this. We had 2 cases happening simultaneously. When Trump went into Judge Chutkan at the federal level and said, hey, I've got immunity and I'm going to appeal this all the way up to SCOTUS, she paused everything because she had to. But the same thing was going on at the state court level, and they said, we're not pausing anything. Are you kidding me? We have to get Trump convicted before the election comes down, or else we're going to lose, even worse than we did under Biden and Kamala's stewardship. So here they issued their decision. Trump thereafter sought leave to file a second. Okay, so he says, hey, first time he tries to remove it, denied. Doesn't fall within the law. Second time he says, hey, the Supreme Court just came down and said, just what I said, I have immunity. So he now says, let me remove again. But that was filed untimely, right? Because it was just outside of the permissible time. The trial's already over. And this establishes, he says, well, the other provisions establish a procedure of removal for good cause, to say, hey, I can file late. I've got pretty damn good cause. The Supreme Court just came down and said I was right. Now, Trump argued principally that the Supreme Court's intervening decision rendered the state's prosecution that is relating to his official acts as now being removable. Okay. And Trump was prosecuted in this court for his official acts. They brought in Madeleine Westerhout. They brought in Hope Hicks, 2 government employees, to talk about what Trump was doing during his time as the president. So the district court denied leave, said, no, we're not removing this. This is staying with Alvin Bragg, concluding, among other things, that good cause was not shown in seeking a removal. And now the Court of Appeal says, wrong. We cannot be confident that in doing so, the district court adequately considered the good cause inquiry. Those issues include, but are not limited to, the impact of this. The Supreme Court just came down. That's pretty damn good cause. Now, the district court did not even consider whether certain evidence that was admitted to the state court even relates to immunized official acts. Didn't even think about it. Or whether evidentiary immunity transformed the state's case into one that was basically under the color of the presidency. The judge didn't consider a bunch of things, and so therefore, we vacate the district court's order denying Trump's motion to remove or file the second notice of removal, and we send this right back down to her desk for a remand, for reconsideration of the motion consistent with this opinion. All now coming from the Second Circuit in a decision that is per curiam. It's the decision of the court. Here's more background on this. They say, all right, listen. The federal officer removal statute, it permits a defendant in a state criminal prosecution to remove the case to federal court. That's exactly what Trump was. Federal officer, the highest, who is being charged under the state for federal crimes. He says, hey, I was a federal official. They're prosecuting me for federal allegations. The federal court should hear that. Now, the statute's basic purpose is to protect the federal government. That's why we wrote it. 28 U.S. Code, Section 1444-2A1. The statute's basic purpose is to protect the federal government from interference by state prosecutorial hacks like Alvin and Fannie and Letish to have to be hauled into state court when we have the supremacy clause. But there are rules that the defendant, in this case Trump, had to follow to take his case out of Alvin and Mercan's court up into the federal courts. Among them is the requirement that he files within 30 days. But even that requirement has a little play in its joints. On a showing of good cause, the court may still consider the removal. So this appeal from the president, we got to ask two basic questions. One, whether the state prosecution of then former President Trump was removable based on the statute. And two, whether the then former president actually showed good cause within the meaning of the statute to file a notice of removal well after his arraignment, his trial, and his verdict based on the decision from SCOTUS. And remember, Mercan knew that Trump was appealing these issues and he should have stopped it at the time, but he said, no, we don't have to do any of that. We're just going to move this forward. Those are federal claims. I don't care. Because the district court does not appear to have considered the important issues, yeah, it doesn't appear. That's on you, judge. Bad judge. Doesn't appear that she even did her job at all. And didn't consider the important issues relevant to removability of the underlying state prosecution because they didn't care. They had a mission. And this was before the election. We've seen how these federal judges have been acting in recent months, ever since Trump actually took the White House. They were doing it before. This was like a nationwide injunction, right? Type of an action to, oh, no, we can't hear this case. Alvin, you run with it. Why don't you take Matthew Colangelo, the number 3 at the Biden DOJ, who just left his office to go facilitate these prosecutions, and we'll just let the state handle it. With acting Judge Mercan. Says, now it's remanded, and you better reconsider this, Judge, and do a good job this time, okay? In March 23, a New York State grand jury indicted Trump, 34 counts of false business records, saying Trump tried to influence the 2016 election, paying Stormy 130 G's. I think there's a new image of her going around. Have you seen that? I don't know if that's real or AI or what, but gosh, rough. Friends don't let friends make false allegations against other people, okay? Not even once. You'll turn into a meth head. Trump sought to remove the criminal case against him to federal court. The district court remanded the case to state court because it said, oh no, you can't remove this. These are state crimes. Alvin said, we're not even going to talk about federal charges. Then at the trial, he's like, well, we think it could be federal charges. Jury, pick a crime, any crime, and one of those is a federal crime. Following a nearly 7-week trial in state court, okay, and Trump was running for president, they shackled him down to the seats in the judges' chambers for 7 weeks in the middle of an election. So every time they come out and screech and shout about weaponization or retribution or whatever nonsense that comes out of their mouths, you can just point to this. They shackled the president down for 7 weeks in the middle of an election. Illegally. The case shouldn't even have been there. Should be removed. A jury convicted Trump on all 34 counts. On July 1, after Trump was convicted in this rigged court, but prior to the sentencing, okay, so the case is still open, the Supreme Court issued its presidential immunity decision, which was obviously how it was always going to come out, because how does everybody else have immunity except the president? Makes no sense at all. We already saw the Nixon precedent with civil immunity and all these other things. So the courts knew better, but they didn't want to hear it because they needed to convict him. In Trump, the Supreme Court case, the Supreme Court held that the president is absolutely immune from criminal prosecution for conduct that he's allowed to do. If he has the constitutional authority to do those things, you can't prosecute him for doing his job. Makes sense. But Judge Chutkan couldn't figure it out. Judge Mercan couldn't figure it out. They could figure it out. They just didn't care. Separation of powers, the court said in the Supreme Court, necessitate that there's at least presumptive immunity for criminal prosecution within the outer perimeter. And remember, there were the 3 buckets. One, if it is constitutionally dictated, the president can do it, he's absolutely immune. If he can make the argument that he has the authority to do that under the Constitution, it's presumptively immune. And the other side can show why it's not protected. And then, of course, if it's absolutely nothing to do with his job or role, then that would not be immune conduct. We have the three buckets, creating a spectrum. Most relevant here, the Supreme Court also said, even when an indictment alleges only unofficial conduct, prosecutors may not introduce evidence of the immune conduct. So if Alvin is saying there was a crime, then he can only talk about the allegations that create the crime, right? The facts and circumstances that would lead to the criminal charge. But if any of those actions, if any of that evidence is official, business, you can't use it unless you can show it falls into that third bucket that has no immunity. Now, in light of this decision, Trump then says, I'm totally vindicated. All these prosecutions were rigged because they brought in official acts evidence about how Trump was responding to the media as the president, clearly within his purview. This time, Trump sought to file a second leave. He says, hey, I got good cause now. Supreme Court says I'm 100% right. Now, he said, I know it's untimely. The rules say you got to file it immediately within 30 days. And I didn't do that because the case has been going on. We lodged our objection at the beginning, but Merchan didn't pause it. Judge Chutkan did pause it. Jack Smith tried to keep the case going until Judge Chutkan had to shut him up too. Say it's on appeal. I can't really do anything here. Among other things, he argued that the state's prosecution was related to his official acts. And that means the case is removable. Now, the district court denied it again. They say, sorry, your filing's late. You can't submit this one in my court, she said. He says, well, that's good cause. The law says if there's good cause, in this case, the Supreme Court, then I can do it. She said, no, sorry. Like that one teacher or professor you had. After Trump's election as president in November 2024, what a glorious day that was. The state court imposed a sentence of unconditional discharge, right? Merchan said, I really can't penalize you at all. So no probation, no fines, no jail, no penalty, unconditional discharge. The most lenient sentence possible in light of the conviction. Because all they wanted was that little mark on it, a scarlet letter. We're going to brand Trump a felon. Trump appealed his final judgment of conviction to the appellate courts, where the appeal remains pending. But Trump also is now saying, you should have let me remove this case up to federal court after the second notice was filed, after we had very good cause because the Supreme Court said so. They go into part two. New York law, writes the Second Circuit Court of Appeals, obliterating the lower court judge, it makes it a first-degree felony for any person to make a false entry into business records. And of course, we were following the bouncing ball. Then they turned a misdemeanor predicate into a felony to commit another crime or to aid or conceal the commission thereof. A state grand jury charged Trump with 34 counts in violation of the law. Now, according to the indictment and the evidence that came out at trial, they said Trump orchestrated a scheme. Shortly before the election, they said Michael Cohen, a convicted perjurer, his lawyer, paid Stormy, another, in my opinion, liar, $130,000 to prevent her from publicizing an encounter. And the reason I say that is because Stormy Daniels wrote multiple times that there was no affair. It never happened. She said here many times, no affair right here. Remember, she wrote that January 30th, 2018. Over the past few weeks, everybody's bugging me about this. The fact of the matter is that this alleged affair, I denied it many times. She said I denied it 06, 11, 16, 17, and now again in 18. I'm not denying this affair because I was paid hush money, she says, as has been reported in overseas owned tabloids. I'm denying this affair because it never happened. It's her own writing, her own signature. All there. Then, of course, the election comes around, and so she needs to act in order to elevate her status by attacking somebody who the Democrats want to stop. So she's a liar, in my opinion. Following his client's instruction, Cohen, the lawyer, perjurer, then paid Daniels using a shell corporation. After the election, Trump reimbursed Cohen through a series of checks, they allege, to disguise each check as payment for legal services when it was really a campaign expenditure. The Trump organization maintained the records. There was no retainer agreement. And instead, according to the indictment, Trump was the one who caused his entities to falsify the business records to hide the criminal conduct. So then Trump, of course, April 4th was arraigned in the Supreme Court of New York in the sham prosecution. A month later, he filed a timely notice. He says, okay, they're saying I falsified the record, so I misclassified it. It's not a payment to a lawyer. It's a campaign expenditure. What governs campaign expenditures? Federal law. Oh, okay, because I'm running for federal office. So they removed it, or tried to. They told the lower level judge, they're charging me for crimes that I committed, allegedly, while I was the president. And many of the checks, I think all of them actually, were signed by him as the president. So the state moved to remand the case to state court. They said, no, this is not a federal crime. It doesn't involve any federal allegations. And after conducting an evidentiary hearing, remember Alvin Bragg went over there, or somebody from his team. I'm not sure he does anything actually other than talk and eat. But the district court concluded that Trump had failed to meet his burden of establishing removal because Alvin came in there, his office, and said many times, we're not charging him with any federal crimes at all. So it's a state case. So just leave it here, federal judge. It's not your business. She said, you're right. It isn't my business. She explained, she says, well, hush money paid to a film star is not related to his official acts, and it doesn't reflect in any way on the official duties. And so they said, it's none of our business. Yeah, but they're saying that it was a campaign expenditure while he was running for federal office. And as the president, he responded to that and explained himself in defense of the payments to Michael Cohen, and they brought all of that in as evidence against him, is the problem. The court accordingly granted the motion. And Alvin brought that evidence in, okay? And Trump's response, and they brought witnesses, Hope Hicks, the testimony. They brought Madeleine Westerhout to testify about what Trump was doing, talking about inside the Oval Office. All the things he's allowed to do came in as evidence. Never should have happened. Trump appealed the decision, but for reasons that are not clear on the record, dismissed it later, and the criminal trial began. On May 30th, a day into deliberations, the jury came back, 34 counts, Trump's guilty. Incredible. Then on July 1, before Trump was scheduled for sentencing, the Supreme Court came down. They issued their decision. In addition to providing for at least a presumptive immunity, okay, we got three buckets, absolute, presumptive, and none. They say, if it's within the outer perimeter of his responsibility, like if he can make the argument like, hey, nope, I got these broad powers, it's in here, then he gets it. The court said that even evidence of the president's immunized official acts is inadmissible. Can't bring in Madeleine, can't bring in Hopes, can't talk about all of the official acts. He's allowed to do those things. And they were using it to imply guilt. Because the intended effect of immunity would be defeated, if you're immune from the process. You're immune from that evidence from the trial. You can't just like say, oh, well, now that I've been found guilty, I'm going to pull out my immunity card. The process is the penalty. You're immune from the penalty from the process. Because the intended effect of immunity would be defeated if the official acts could be scrutinized, and you're like, we're going to convict you for doing what we elected you to do. The Constitution says you have to do this, and so now you're going to jail. What? It doesn't make any sense. The court explained, evidence must be inadmissible, even when the indictment is saying, well, it's only alleging unofficial conduct. Okay, that's fine. Unofficial conduct, you can prove with unofficial evidence. But if it's official business, then you can't bring it in. And they did that. Now, in light of this decision from the Supreme Court, Trump first moved in state court to dismiss the indictment. He said, hey, Juan, the judge, I am right. You are wrong. Judge Chutkin got the same message, and that case was dismissed. It didn't proceed to trial. Now, here, the judge said, I don't really care, and continued with the conviction. When the state court Judge the Khan denied it, Trump tried another tact. He said, hey, how about I go and just remove this case again because I've got good cause now. The Supreme Court just said I'm victorious. And he filed nearly 2 months after the Supreme Court another removal. And of course, there's a different section of the law, B1, governs the procedures for removal. They say you should file within 30 days. Hello. But if you have good cause, then you can file later. And there's a little bit of a delay. Like it would have been nice to have them file that 10 days after the Supreme Court. Hey, oh my gosh, look what just happened. But motions take time and they had to research some things. So 2 months, not bad. The district court thus initially rejected the second notice. They said, sorry, this is untimely. It's not good cause. This is not even new. He waited 60 days or whatever she said. On September 3rd, however, Trump corrected the error and filed a motion to leave Okay, so basically, she says, sorry, before you can file your second notice of removal, you have to get permission from me to file a motion for leave to file a second notice. She's like, nah. And so he's like, all right, fine, I'll do it. Now, that is the motion issue on appeal, and Trump is going to win this one. Now, the district court, they say, soon as Trump sent that in, she denied that motion in a brief order issued the same day. Didn't even read it. Just like, oh, Trump requested something? Nope, deny it. Do you want to read it? No. It's Friday. Are you kidding me? No, I don't want to read anything. So denied it the same day, probably hours or minutes. Describing many of Trump's challenges, she said, well, if he's unhappy about it, he can go to the state courts in New York and appeal over there. The district court said Trump had failed to show good cause. It's too late, sorry. She said, the Supreme Court doesn't say that anything that you're alleging affects my prior conclusion. The actual hush money payments, they were private. They were unofficial acts outside the bounds of executive authority. So she says, well, my original decision would have put those into that third bucket, and signs it within minutes. Now, Trump appealed that to us, and that's where we are now. He moved in the district court for a stay, asked for an emergency stay, and again, they denied it. She said, no, sorry, there's no action. There has been no removal. None of this is proper. And by then, however, the state court, Judge the Khan, adjourned sentencing until after the presidential election. He said, we'll postpone it. So in light of and then Trump won. In light of the adjournment, this court denied the emergency stay motion and said, sorry, you lose again. Okay, this judge, no, denied, no, denied, no, denied, until this one. Now, on December 2nd, after his reelection, all the Democrat fraudsters all go, oh, crap, we just tried to destroy him, and he won anyways. Trump filed another motion, again, before the state court trial judge, the Khan, that had presided over his criminal proceedings. He said, hey, you have to dismiss this now and vacate the verdict because I've got the Supreme Court and the presidency. The trial court denied that motion again, January 3rd, 2025, and scheduled sentencing for a week later. Remember this? Trump was the president-elect and had to go in and get sentenced by a maniac, corrupt judge, in my opinion, but declared that it was inclined to impose any sentence of incarceration. Of course not. He's the president-elect. What are you going to do? Trump then, as the president-elect, moved in the state appellate courts, and he wanted to stay the sentencing. They all denied it. Supreme Court had the final word. A day before, they said, you're getting sentenced. Okay, this was like their consolation prize. They were so mad that he won that they had to come and just sentence him. Like, it's going to feel so good to sentence him. He's going to be a convicted felon. Okay, you guys lost everything. The court held that the evidentiary violations can be addressed on the course of appeal, and that we're not even going to sentence him bad. In light of the trial courts, we're going to impose unconditional discharge, no jail, no fine, no probation, no reporting, nothing. It's going to be a brief virtual hearing, not even going to make him show up. On January 10th, the trial court sentenced Trump unconditional discharge. And guess what? Trump became the president 10 days later. Historic, our first felon president, 34 too. He probably is going to hold that for a long time. Nobody's going to beat that. On appeal, Trump argues that the district court erred. They screwed up. You should have let us remove this case, and you done goofed. The state court says, and the state, in this case, BRAGG and his goons, they respond. They say, all of this is moot, okay? The case is over. He's been convicted. There's nothing to remove anymore. The entire appeal is moot. They say, even if the appeal is not moot, Trump has no good cause. He can't file this notice for removal. And they say, well, sorry, Alvin. We conclude that the appeal is not moot. We vacate the lower judge's order that denied Trump's motion, and we remand this case back down to her to reconsider what she has done with her life and this case. And do a good job this time to reconsider Trump's motion. Now, the first question is whether the case is moot. A case becomes moot if there's no longer a case or controversy. The state says it's moot. Trump has already been sentenced, okay? The case is over. We got it through. There's nothing to remove anymore. The case is closed. But the state's argument in favor of finding that this case is moot assumes on the merits that a federal officer defendant can never remove as long as they have been sentenced. It's like as long as you get that TV outside the door without paying for it, As soon as you get past those little metal detectors, you're good. That's how this works? No, come on. Now, as discussed, this is an open question, and whatever we think of the obstacles that Trump faces in obtaining removal at this stage of his state criminal proceedings, it's not about mootness. At this stage, there is a controversy. Trump has at least some prospect of successfully removing the proceedings to federal court and obtaining the relief he seeks. We cannot say that he has no concrete outcome in the interest of this case. It's clearly still open. It's not moot. He's moving forward. Now, on the merits, the other question is whether the lower level judge erred in denying Trump's motion. And so we're going to review that to see if this judge abused her discretion. She did. A district judge abuses or exceeds discretion when it rests its decision on an error of law, or if there's a clearly erroneous factual finding, or if its decision cannot be located within the range of permissible decisions. The law says the following: file your thing within 30 days, but if there is good cause shown as to why you didn't file it within 30 days, like, for example, the Supreme Court came down and vindicated you, then you may file the notice at a later time, right? But you got to ask for leave. And the judge's like, well, you didn't ask me first for leave. You just filed it. Like, okay, fine. Here's our permission slip. Can we file it? She's like, okay, file it. Like, we file it. She says, nope, denied. Although the parties have focused much of their attention on good cause shown, there remains the question whether a federal officer defendant can ever remove a state criminal prosecution after he's been tried and judgment entered. Now, as already noted, like, is the case closed? It's over. As noted, this question relates to the merits, and there may be viable arguments from either side to permit removal at this stage, or it could prohibit it. We're not going to answer that question now because the district court didn't address it either. So she needs to go decide that on remand. And both sides need to brief this to decide whether this is moot or not. It hasn't even been decided. She didn't even consider it. Now, by contrast, we're going to let her deal with that, but we're also going to address the meaning of good cause. In defining good cause, we draw on the definition. Although not necessary to our resolution on this appeal, we are mindful of two background principles. One, that federal officer removal is not narrow or limited. Okay, this is the Cuomo case, who just got obliterated by Mamdani. He's walking around New York now, just kind of contemplating his existence. But second, the Supreme Court has also said that the statutory procedures for removal should be strictly construed, and respect for the limited jurisdiction of the federal courts and the rights of the states compels us to resolve this interpretive doubt. Okay, so there's like a tension here. Federal officers, their power of removal is not narrow. It's not limited. It's broad. We want to protect our federal officers, but there's a process to do it, and they got to stick to that process. If they go outside the process, then they can't do it. So there's this tension. Does he have the right to remove it? And did he follow the process in this little tension? Now, here they continue explaining. We interpreted in prior cases the term good cause under the rules, and we looked at all of these cases. We also looked at the federal rules of criminal procedure. Here's another Second Circuit case from our precedent. We have Alexander versus Saul, lots of case law and rules. And as we go through all of that, we analyzed all of this and this and this and this. As applicable to this case, we consistently read the good cause standard to require movements to demonstrate that circumstances in this case, Trump, to demonstrate, hey man, there's circumstances outside our control. We couldn't have filed this within 30 days because we didn't even know that there was a Supreme Court decision that was going to be coming down any minute, and it did. Now, in defining good cause to permit the filing of this, we see no reason to diverge from our past interpretations. And so we therefore hold that a criminal defendant, in this case Trump, who moves for leave to file an untimely notice must show at least two things. One, circumstances outside his control occurred. Supreme Court decision, he didn't control that. Including if there are new grounds for removal that he could not have raised before the 30-day deadline. We didn't have a decision. That prevented him from seeking timely relief. And number two, after he got notice, oh, I have all this new power now, thanks to the Supreme Court that dictated that, has always been the case. He sought and acted with reasonable diligence to file the petition, and he did. Now, of course, we also keep in mind that in other contexts, Good cause also reflects a flexible standard. You got to consider a bunch of things. Another Second Circuit case, and the court can go through that analysis. But the district court cited two reasons for denying Trump's motion. The first one requires little discussion. The second one we'll dig into. But they write, first, the lower level judge improperly invoked one doctrine called the Rooker-Feldman doctrine. She said, we don't have any jurisdiction to hear your arguments. They say, what? That case concerns the limited circumstances in which the certiorari statute precludes a district court from exercising jurisdiction in certain cases. Now, because this doctrine implicates statutory rather than constitutional jurisdiction, it doesn't bar a district court from exercising jurisdiction over properly removed cases. So it was error for this judge to say, I can't hear your case, right? She cited this doctrine. She's like, well, this case law says I can't hear it. What? Yes, you can. They said, you're not even reading the case right. Now, the district court's second, also independent basis for denying Trump, she said, well, the Supreme Court didn't say anything different. Nothing in the Supreme Court's opinion affects my previous conclusion that hush money payments were private, unofficial acts outside the bounds of executive authority, and you haven't shown any good cause. That's all she writes. Now, while acknowledging the decision, the lower level judge, who's wrong, does not appear to have adequately considered the Supreme Court case and whether that a change in the controlling law, which is what they said in the SCOTUS, I don't think they changed anything. I think it always existed. There was immunity. We just didn't have psycho prosecutors at the state court level who would weaponize their offices to attack the presidents. Just hasn't happened yet. So the Supreme Court had to come out and say, obviously there's immunity, idiots. As noted, a state court action brought against a federal officer may be removed if there is a colorable federal defense. That's it. So a question that naturally arises in connection with the good cause inquiry that the judge should have done is whether Alvin Bragg's prosecution of Trump ever related to his official acts as president. In urging the answer yes to that question, Trump says, yeah, they did. They brought in all sorts of official acts evidence against me that I'm allowed to do. They used it to imply and impute my guilt. Said that the state, Alvin's office, improperly relied on at least three categories of official acts evidence that is all later precluded by the Supreme Court. First is the testimony that Trump, they came in and testified, they said, President Trump, as the president, allegedly told Michael Cohen that an FEC inquiry would be taken care of by the attorney general. And of course, Trump can talk to his attorney general. Trump can talk to his lawyer. Trump is the president. He's allowed to do all those things. That testimony should be immune, meaning it should not come in. Now, second is the testimony from Hope Hicks, as we mentioned. White House comms director, she was asked specifically about private conversations with Trump about matters of public concern. All these allegations are coming against the president. Happens every day right now. Oh, Trump's crypto and Trump's with Qatar and Trump's airplane, whatever. Constant nonsense, right? And the president can respond to those things. Just like in this one. Hey, there's an allegation that you paid off a porn star. Did you? No. And here's why. And they use that all against him. Hope Hicks, what's the strategy? How do we respond to these media attacks? All part of the job. They also brought her in. They had her testify about Oval Office conversations. And third is another category, Trump posting on X on Twitter. He was offering official communications from the White House in response to these allegations. He's allowed to do those things. All of those were official acts. All of those were brought in as evidence against him, and they shouldn't have been. The federal removal statute, he says, protects me against claims when I can make a defense that's based on federal rights, in this case, immunity. Decisions interpreting the statute after its enactment, they also held that the color of office test shows that there's a causal connection, and other laws are all being fleshed out here. 2011 amendment, this other case in whatever year, 2011 that was, another 2023 case. Meanwhile, Supreme Court has also offered guidance as well. But whether the new Supreme Court case constructed a new road for removal turns initially on whether any of those three categories we just talked about actually relates to immunized official acts. So if so, they're not going to decide it here for us. But the judge should respond to those things. If so, there remains the question whether admitting that evidence, whether it transformed Alvin's corrupt case, state case, into one that relates to acts taken under the color of the presidency within the meaning of the removal statute. There are other substantive and procedural legal questions also raised by this. Remember that the federal laws say that there needs to be a colorable federal defense. You can make the argument for one. Were the state prosecution by Alvin somehow related to his official acts, the lower level court would have had to consider whether a challenge of that evidence is a federal defense, or more broadly, whether the Supreme Court decision or changes in the state's theory of prosecution might recreate Trump's federal defense based on preemption under the FECA. Remember that? And Alvin came in at that lower level evidentiary hearing when the judge was rejecting Trump and said, we're not even going to talk about that. The FECA has nothing to do with our case. Then he ran his mouth all about it in his closing arguments. Now, even if Trump could establish new grounds for removal existed that he could not reasonably have raised at the beginning, he would have to demonstrate he acted diligently and without undue delay. Otherwise, there is no good cause. Okay, so it's got to be something new, and he acts quickly. Now, the state says he did not act with reasonable diligence. They say he waited more than 2 months. That's a long time. So he needed to go faster. They say he should have exercised diligence and sought relief immediately. Trump says, what? That's it? 2 months? My delay was perfectly reasonable. The Supreme Court just issued a major decision. We filed 2 months later. We had other urgent legal matters requiring the attention of the legal team, like running the country and winning the presidency. So it was very reasonable. Now, at oral argument, however, Trump acknowledged that he could have sought removal immediately, but they opted to instead to give the state court judge an opportunity to address this. They said, hey, we only filed for removal again after we went back to Judge Merchan and said, you now have to dismiss this. You should have granted us immunity and precluded all of that evidence from coming in, and you didn't do it. So now you can correct your error, Judge the Khan, and dismiss it. And he says, no. They said, okay, fine. Then we're going to take it up for removal. According to lawyers, Trump sought removal only after the state court suggested that we're not going to reject your immunity argument and we're going to sentencing. So it's like, oh, okay, well, that makes sense. So you tried to handle it here and now they're not. So we're okay. So in its denial, however, the district court did not even talk about this, whether Trump acted diligently. In fact, the district court did not grapple with any of the central issues that we have identified above. What a terrible judge. Didn't even care. Came in, she was out having tea or whatever, and just said, denied. She explained only in her decision that nothing in the Supreme Court's opinion affects my previous conclusion that these are private, unofficial acts, and that's it. The court bypassed what we consider to be important issues bearing on the ultimate decision on the issue of good cause. Now, as here, where the district court failed to consider the relevant factors, and we cannot determine whether it abused its discretion, the usual practice is to send them back down to the judge. Both parties at oral argument, both Bragg and Trump, they helpfully acknowledged that if we were to conclude that the district court did not properly exercise its discretion, this court could remand it back down to her. And having determined that she did not address significant issues that are relevant to this entire case, we vacate her decision, gone, and we remand it for development of these and other relevant arguments. So it'll go back down to her, and I'm sure she'll rig it again. But specifically on remand, the district court should consider the factors relevant to determining the good cause listed above. And they're basically saying there is good cause. Like they fleshed out Trump's entire argument. This presumably would entail closely reviewing the 3 categories of evidence that Trump claims were in there and determining whether, in fact, the state's use of that evidence means that the president was being charged under the color of the presidency, as the Supreme Court just found. And of course it was. If the district court finds that the prosecution is related in this way, it should then evaluate whether both Trump has a colorable federal defense and whether he diligently sought removal. So she's got a couple of options to deny him again, but they'll just take it back up and say you were wrong again. The district court should also determine whether removal under those statutes is even available at this stage of the proceedings. Now, we leave it to the able and experienced district judge that you guys just reversed for not even considering any of the key factors of the case. That's like a little bit of a, you call that like a compliment sandwich. It's like, hey, judge, you kind of screwed up. You're amazing. We love you, but you're wrong again. Kind of one of those things, right? Or I think it's the other way. You're supposed to put the bad thing in the middle and then compliment sandwich it, right? She's experienced and capable. We just spent 27 pages explaining why she was wrong and to do it over again, but she's very capable. Whether to solicit further briefing from the parties or hold a hearing to resolve this, we express no view on this, and neither rule nor imply that she should resolve this in any particular way. So she can do whatever she wants with it, but she's dead wrong in how she handled it the first time. And so we simply direct the lower judge to consider anew in light of this opinion. And so for the foregoing reasons, we vacate this judge's order denying the request of Trump to remove this, and we remand it right back over to her desk to do it right this time. And we understand what she's going to do. Okay, she's going to deny it again. Trump's going to appeal it again, and around we go. But she just got scolded and said, hey, all of these other factors from our perspective in the Second Circuit feel to be pretty solid for Trump. And they could have just said, no, you're done. I mean, obviously you can't remove it. It's over. Case is closed, whatever. They didn't. They said, do it again. And they gave her some nice frameworks to do it. So she's going to have to really work overtime to contort herself to deny it again. But we're expecting her to do it based on prior practice. Now, the president was out yesterday and he was saying, you know, we got a real problem here with all of these prosecutions against me and the crimes that were actually enabled by the Biden goons, and was explaining that the auto pen pardons are invalid. And so the federal courts now hopefully going to be stepping in on the Alvin Bragg case, taking that away from them as they should, and vacating all those convictions at some point. But similarly, we've got to talk about prosecutions of the people who are part of this corrupt attack. Matthew Colangelo left the DOJ to go collude with Alvin Bragg. We know that Jack Smith was colluding with the J6 committee. They all got pardons. Then, in our opinion, Jack Smith passed it off to Fani Willis after attacking Harrison Floyd and many other people down there. So the list goes on and on. Now Trump is saying it's time to turn the tables on them.
I believe in that. You know, I get these guys come in with these big, beautiful documents, gorgeous, beautiful, must cost a fortune. I should check the price. But, you know, a general is being made or something, you know, some big post. And they say, sir, would you sign this, please? It's going to be a 4-star general, or it's going to be a big cabinet position, or it's going to be something with medical or whatever. I take my pen and I sign it. In his case, they walk it into a room and they give it to somebody who's no idea who Biden is. But Biden doesn't have any idea who he is either. And they have a machine sign it, the auto pen. And all of the pardons, he gave thousands of pardons to people. He had no idea about it. He didn't know about it, and therefore all those pardons are void. You know, you have to have, it's a very complicated thing if you're going to use a machine. You have to do it properly. And he didn't have any idea what was happening. And this is what we had as a president. We don't want that. You have the opposite right now. I don't want to be braggadocious, but you have the exact, I know exactly what's happened. If you want to see what congressional Democrats wish to do to America, just look at the result of yesterday's election in New York, where their party installed a communist as the mayor of the largest city in the nation. Remember, I've said we will never have a socialist elected to any post in our country. I used to say that, and I was right. We skipped socialist and we put in a communist instead. That didn't work out too well. But as I've warned for many years, our opponents are hell-bent on turning America into a communist Cuba or socialist Venezuela, and you see what happened to those places. For generations, Miami has been a haven for those fleeing communist tyranny in South Africa. I mean, if you take a look at what's going on in parts of South Africa, look at South Africa, what's going on. Look at South America, what's going on. You know, I'm not going to, we have a G20 meeting in South Africa. South Africa shouldn't even be in the G's anymore, because what's happened there is bad. I'm not going. I told them I'm not going. I'm not going to represent our country there.
All right, so the auto pen pardons are a joke, and the DOJ, of course, investigating many of those people. We're going to keep our eye on this. The Trump prosecutions now stalling out even more after the removal battle continues, and we'll see if they take this case away from Alvin Bragg's state courts, where it was being conducted by Juan the Con Mercan, the guy who gagged Trump, didn't want anybody talking about his Democrat daughter, the guy who donated multiple times to Joe Biden and stopped Trump Republican PACs and all the things, kept the case, rigged the prosecution against the president, and now there's some oversight happening. So we'll keep our eye on this one, my friends. Thank you for subscribing and joining as we do. All right, now let's turn our attention over to the Charlie Kirk case, because we've got some interesting filings that are coming out. The media rising up saying, we want access to the Tyler Robinson, Charlie Kirk trial. Bunch of them came in submitting this motion in the case in Utah, explaining that we have all the media companies, including the Salt Lake Tribune, Associated Press, Fox News, Park Record, CBS, New York Times, CNN, Law and Crime, all now crashing into the court as media interveners, saying, listen, if you are going to close this case down, if you are going to seal it up, reclassify anything, or do any of the weird things that we've been covering here, you got to let us know. We have a First Amendment right to get in here and see what the heck's going on with this public prosecution. And we've covered this sometime before, raising our eyebrows, going, boy, why is everything so locked down in this trial? Why are the prosecutors agreeing that they want to appear telephonically and just show up virtually in these hearings? And why did we only see Tyler Robinson at his initial appearance on 9/16? And then when we had the waiver hearing on 9/29, didn't see him at all. Cameras were off the entire time. No real evidence that he was even in the courtroom or in the jail, which is where they said he was, because we couldn't see him. Then we were paying attention. Maybe it was just a weird thing the second time. Why'd the cameras go off on 10/27 again? We couldn't see him. Then we reviewed the motions and we saw the prosecution and the defendants were playing patty cake with each other. Like, yeah, virtual appearances are great. Prosecutors don't want to have to put pants on and make their way into court for a national assassination case, which is shocking to me. And then similarly, the media should be precluded from attending. Really, they were all kind of agreeing, saying, we don't even want cameras in the courtroom. The media is saying, Judge, you cannot allow that to happen. And so there's been a bunch of activity on the case. Of course, this is the Tyler Robinson prosecution. He's got multiple charges, 7 counts here, all of them listed. We've covered those many times. But here's what the docket looks like. Been a lot of activity lately. And what we're covering today is this filing right here, November 5th. Motion for limited intervention and request for notice of motions coming in from the media. We're also going to look at this November 4th filing, which is a new order from the judge who will explain what's coming next. But here is what the media is saying. All of them coming in here saying, listen, we're filing this motion and we want limited intervention in this case. Okay, so basically add us as a party so that we're properly apprised of everything that's going on. They say, you, Judge, you've already noted that the media interest in this trial is arguably unprecedented in the state of Utah. You've also recognized that the public's interest in and the newsworthiness of these proceedings is palpable. So to safeguard these rights of the press and the public to access these highly newsworthy proceedings, the media is now coming in here, all of us, asking the court to grant this motion for limited intervention and enter an order that we can be apprised of this. We want to know about all motions or other requests that would limit access to these records, serve us with the materials. We also want to be allowed to respond and be heard on access matters before any order limiting access in this matter is entered. Okay, let us come in here and just make our rights known. Here's the summary. Media interveners are media entities. We're engaged in the business of gathering and disseminating the news. The group includes both local outlets focused on Utah communities and national news organizations serving everyone else. All media interveners share an interest in ensuring access to this criminal proceeding, and we want to contest any closures or restrictive classifications including those closures and classifications that have already taken place or been requested. In the 6 weeks that this matter has been pending, the court has carefully protected the press and public access rights. As the court said, this is a serious case. It's garnering national attention. And from the start, that attention has included media requests to access this case. The court has routinely and appropriately granted those requests, imposing conditions as needed to account for other competing interests. Okay, so like Judge, you've been doing a pretty good job so far. Thank you. But unsurprisingly, both parties have attempted to chip away at those access rights almost immediately, as we've noted. On October 9th, Tyler Robinson, the alleged assassin, he filed a motion to appear in civilian clothes. When it came time for the state to respond, it moved to classify its response as private. In justifying that classification, the state stated, the prosecutors, that the response includes information about the court's security director, about specific security measures, and so we can't share it with you. All right. Now, even if this were true, the press and the public cannot, of course, verify the contents of a private filing, including whether these security measures could have been protected through redaction rather than private classification. The state appears to have used that private filing to argue for limiting press and public access to these proceedings. Why would the prosecutors want to do that? In Section 5, like, did the prosecutors do that for to like limit and protect Kyle Rittenhouse? We don't want any images or photos of Kyle Rittenhouse. We have to lock the media down for that. Or how about George Floyd or Derek Chauvin? Did they bend over backwards to protect the media rights and the privacy rights of Derek Chauvin? Don't think so. Or Kyle Rittenhouse? Don't think so. In Section 5 of his reply, defendant stated that he agrees Tyler Robinson with the county sheriff, okay? They're playing with each other, that the court should limit media coverage or video or photographic coverage, or at the least, so defendant's physical appearance is no longer the subject of interest. So you can't see who he is. Based on that reply, the media says this is ridiculous. We have no way. We understand that in addition to relaying details about security measures, the state also, the prosecutors, the media saying, also made broad arguments about limiting media coverage in this case altogether. For what? Media interveners, of course, oppose those arguments on the merits. And just as critically, however, media interveners object to the practice of placing arguments about restricting public access to these proceedings in a non-public filing. And I've been watching this case, waiting for this stuff, and it's not in the docket. And we've been asking the same thing. Where is the conversation and the confirmation that Tyler Robinson is actually in the courtroom or in the jail, rather? And I believe he's there. You know, I'm not like he's gone somewhere or, you know, in some foreign country or something. Like it's all just made up. This is just a giant show. I think he's there. But why not show us? It's because they're so concerned about images spreading around of the guy. Again, where was their concern for Kyle Rittenhouse? Where was their concern for President Trump? Or Derek Chauvin? They didn't care. They spread Trump's mugshot everywhere. They had cameras following him in and out of the media. So why is Tyler Robinson getting some special privileges? Why are the state prosecutors acting unlike all of the other prosecutors in order to protect the defendant, whom they are supposed to be prosecuting? The media is now calling it out. We were ahead of it. We said, oh gosh, this feels very strange. They're playing like footsie with each other. The defense and the prosecution should never be that way. And the judge has been the only one thus far who has not indulged. And they're filing stuff about limiting the public behind the scenes, behind closed doors. What are they doing? Fortunately, the court again protected the press and the public's access right, in spite of the prosecutors trying to undermine it. In granting in part and denying in part the motion, the court declined the invitation to enter orders limiting media coverage, and instead, this court made a set of practical amendments to the decorum order, including targeted restrictions about when he can be recorded or photographed, which of course included not photographing him in shackles. But did the prosecutors make that request? Or is the judge making this request and the prosecutors would be happier with nothing? In doing so, you, Judge, you reiterated your commitment to open and fair proceedings. You recognized the public's interest in the newsworthiness of this, and you identified a benefit in allowing the public to observe the media. And you sought to promote a healthy balance between his constitutional rights and the public. But the court should not be forced to police these critical interests alone. The prosecutors should also be in favor of transparency and public right of access. And in fact, as detailed below, the media also hold a constitutional right to intervene when the prosecutors are betraying us in a limited capacity to oppose any attempts by our own government to restrict public and press access, especially in a case like this, man, where everybody's talking about various conspiracies, whatever you want to call them. You know, a lot of those turn out to be true. So all these different ideas floating around. One nice thing they could do is just be open and transparent about it. So all of that could get evaporated. But they're not. They're locking it down. Why are the prosecutors doing that? Here, the press and the public have a constitutional right. And the presumption of openness that we seek to protect is not even controversial. A lot of precedent says we have unbroken, uncontradicted history supported by reasons as valid today as they were in 1980. We are bound to conclude, said the U.S. Supreme Court in 1980, that a presumption of openness inheres in the very nature of a criminal trial under our system of justice. It's a key component of our system of justice. We don't want trials to happen behind closed doors. And the verdict just comes down and everybody, oh my God, whatever. And no one knows what the hell happened. How is that justice? It's like throwing Edmond Dantes in the Chateau d'If. No one knows what the heck happened. What are my crimes? Who cares? You're going to prison for what? No one knows. And you're gone. We have recognized, even Utah, 1993 said we have a First Amendment right of access to court records, search warrants, subpoenas, documents, all filed in connection with this, citing a bunch of cases. Here's another one. Access to criminal jury selection allowed. Access to pretrial suppression allowed. Access to competency hearings allowed. Access to preliminary hearings allowed. Now, as the court appreciates, that time-honored right of access is rooted in the acknowledgement that open courts foster and protect important societal values. Access enhances the quality and the safeguards the integrity of the fact-finding process. Everyone is accountable. Sunlight is the best disinfectant for cover-ups and crimes. And malicious prosecutions or thrown prosecutions. It enhances basic fairness. It enhances the appearance of fairness in the proceedings, fostering public confidence in the process and actually accepting the results. It's a check on the judiciary, and it allows the public to participate in the government. Supreme Court talked a lot about it. It's been obvious. Now, conversely, if you deny public access to these proceedings or documents, it precludes judicial scrutiny of the process. It creates an impression of unfairness and secrecy. And even though the proceedings may be fair, I hope they are. Hope everything's above board. But we can't confirm that when you hide it all from us and you file your attempts to hide it from us under seal. Openness safeguards our democratic institutions. Secrecy breeds mistrust and abuse. And notably, the Supreme Court has also rejected the false dichotomy often asserted by those who want to close this down. They say public access to the process comes at the expense of a right to a fair trial. They say, well, then he'll appeal. All this media scrutiny will pressure us. And then he'll call that his trial was unfair and appeal it, saying he needs a new trial or whatever. It's like that's their risk. Plainly, the defendant has a right to a fair trial, but we protect the right to a fair trial with public access so we can all see it. Say you had a fair trial. Everybody in the country watched it. So you didn't get unduly prejudiced. Courts have concluded that press organizations have standing to intervene. That's what we're doing. The media and our long-standing request to intervene can come in the form of a motion. We're doing that here. Now, standing also depends on the facts of the case. But our interest here as the media interveners is grounded in the Constitution of Utah. And it allows us to do this. And we have standing to be here. There is no question that the media, acting on its own behalf and on behalf of the public, that's us, enjoys a constitutional right to oppose efforts to restrict access to this proceeding. And only one question remains. How? Should that right be recognized here in order to both protect us and to ensure proper trials? The Utah rules give us some guidance. As part of it, it says, like certain classifications requests, the rule says the person filing the motion shall serve any representative of the press who has requested it. The rules say they get copies. The press gets copies. The rule also reflects a precedent about closures. A closure order must be preceded by notice and a hearing. Members of the media may appear at the closure hearings and be afforded an opportunity to make their pitch. Now, in setting procedures meant to protect these constitutional rights for Tyler Robinson, the Utah Supreme Court, in this case for the press, has also directed, the Utah Supreme Court says, closure hearings need to be open to the greatest extent possible so that we can seek alternatives and exclusions from these hearings, like the media. If you're going to lock this down, you got to let us come in and be a part of it. They need to be narrowly tailored so we can see. Now, by seeking limited intervention, the media says, and in order setting these procedures, we are seeking relief for an infringement that has already occurred. Okay? They're already trying to lock this down. An attempt by the parties to not only seek closure of these proceedings or other access restrictions without proper notice in public hearings, who also hold constitutional issues, but they're also filing for these things in non-public filings. We can't even see it. They're arguing for the closure in secret hearings, in secret filings. They said that the Utah County Sheriff had asked in a private filing that the court should limit media coverage or video or photographic coverage, at least so the defendant's physical appearance is no longer the subject of interest. Well, his physical appearance is a very key part of interest to the public. Was he the guy in the photos that they released? People are talking about his detached earlobes and his hairline, and all these features show us who he is so that we can compare and contrast with the evidence. But they don't want to do that for whatever reason. 2 days ago, the parties doubled down on that. The prosecutors and the defense are playing footsie with each other to shield those discussions from the public eye by asking that the transcript of the hearing where they debated all this crap behind closed doors also be designated as private. And we were covering the hearings and we were watching this. We're like, something is missing here. The judge did not confirm on the record that he could even see him. We never even heard from Tyler Robinson. And so we thought, oh, all of this stuff had to be addressed off record, and screamed about that here. Ignoring narrower means of protecting security or fair trial interest, including a tailored redaction. Why are they covering it up? I mean, it's a court cover-up of their filings that are going to lock the hearing down. And the media is calling them out on that. Why are they burying these filings? Media interveners also asked that the court order the parties to abide by the rules, both with respect to efforts by the state or the defendant to classify documents. With respect to any of these hearings, if you're going to call them private, you got to let us know. A specific order governing attempts to restrict access would ensure that members of the media are permitted to participate in these closure hearings as the rules explain. Media interveners, we therefore ask the court to enter an order that does three things. One, recognize us as interveners so we can be apprised of all these private filings and closed door meetings. And two, require both the state, the prosecutors, and the defendant to provide us with prompt notice of any attempts to try to lock this down. Provide copies of any of your filings or requests. And three, we direct the media, we want you, Judge, to direct the media that we will be afforded the same opportunity to be heard at any of these closing hearings like any other opposing party, so we can make our rights known. Both parties, writes the press, have already sought to limit access to this proceeding. Why? Arguing that the case has garnered worldwide attention. So did Kyle Rittenhouse. It's all publicized. We saw him everywhere. Same with Derek Chauvin. They didn't hide him or protect his rights. Creating a lightning rod for controversy. Yeah. And providing plain platform for pundits and attention seekers with various levels of mental stability. I feel personally attacked on that one. But he has a point. Anyway, defendant has also told the court that this case has already become a content tornado. Well, yeah, they shot and killed Charlie. Are you kidding? A trial that is bound to generate both primary content and more inflammatory secondary content. Like what? Poking holes in your prosecution? But cutting off media access will not eliminate secondary content here, writes the news. It's only going to make it less reliable. We're still talking about it. And now we're not talking about the evidence of the case. Now we're talking about the cover-up by the prosecutors who want this trial locked down. Through its rulings to date, the court has already recognized, thankfully this judge has done this so far, but I got to be honest, I'm not happy with the judge for not telling us about these private filings. Recognize that the critical access interests at play here. To ensure that the press and the public's rights are protected, we ask the court to enter this order. We want prompt notice of any attempts to limit access to this. We want to direct the media to give meaningful opportunities to oppose access restrictions. Let us in on this case. Stop covering it up. And prosecutors who are handling this case should be demanded by the press. Why are they playing patty cake with the defense in this case? And both of them agreeing to appear telephonically and to lock the trial down and to kick the media out. All it does is breed mistrust and elevates our spidey senses. Why are they covering it up? Why is the prosecution, who is supposed to be bringing justice, hiding the process from us? Are they not confident in their case? Do they not think that they have the right guy? Are they worried the public is going to take a look at him and identify something that's concerning to them? That's where our mind goes if they don't keep it open. Everybody else gets prosecuted openly. Trump got abused in his prosecutions and still got a fair trial in New York City. The J6ers got abused. They still got fair trials. So spare us the lecture about secondary and inflammatory content. It's going to get a lot more inflammatory if you don't open up the records and allow us access to this case. I guarantee it. Lock it down and see what happens. It will create a fireball of epic proportions, and rightfully so. If your evidence matches your claims, then we should be able to see it all openly and transparently. Anything that is covered up, we're going to doubt. And we're going to keep our eye on this. I think that Erica Kirk even agrees with us, okay? And so would Charlie, I think, based on her statement here. Here's what she said to Jesse Waters when asked about cameras in the courtroom that the prosecutors who are supposed to be prosecuting her murdered husband are trying to keep out of the trial and out of the court.
The defense wants to ban cameras in the
So do the prosecutors, not just the defense.
courtroom. How do you feel about that?
There were cameras all over my husband
Exactly.
when he was murdered. There have been cameras all over my friends and family mourning. There have been cameras all over me, analyzing my every move, analyzing my every smile, my every tear. We deserve to have cameras in there. Why not be transparent?
Exactly.
There's nothing to hide. I know there's not, because I've seen what the case is built on. Let everyone see what true evil is. This is something that could impact a generation and generations to come.
Exactly right.
The defense.
And so we need to see it. So prosecutors, why don't you have a conversation with the victim of this crime and take her opinion on this and run with it? Stop playing patty cake with the defense. Stop agreeing to appear telephonically, virtually, like pathetic babies. Put your pants on. Go prosecute the biggest assassination of our generation and do it appropriately with vigor, like they did against any other defendant in high profile cases, like you actually care. Erica Kirk would want you to do the same. So we're going to keep our eye on this. We appreciate the media on this. We're on the media side on this one. Go get access to this stuff. Should not be collusion between adversarial sides about media access to this very critical case. Thank you for joining us as we demand access. Thank you for subscribing. We'll see you back here on the next one. All right, my friends. What a beautiful stream it has been. If you're just joining us, 2 segments on the show today. We had an update in the Second Circuit Court of Appeals, big victory for President Trump on the removal issue. And the lower level judge got pretty much scolded. They reviewed her for abuse of discretion, said, yeah, she kind of abused her discretion. Didn't even do her job, didn't even properly analyze the Supreme Court case. So back down to her. And what this bodes is that federal removal is a very strong possibility. And if they take this case away from Alvin Bragg, those convictions arguably should also go bye-bye. We're looking forward to that. We're going to keep our eye on it. And of course, the president was out as well. Then we turned our attention over to the Charlie Kirk case and got a good review of what the media is saying is happening behind the scenes with the prosecutors in Utah locking the case down so that nobody can see it because they are scared of something, I guess. Erica Kirk says, open it up, let the cameras in, and let us see what's happening inside this very important case. And of course, now, my friends, it's time to hear from you. Thank you for being here. Thank you for sending in these very nice donos. We got some new members who are joining us, and we're happy to see you. And locals, friends, and after party membos. If you want to get your comments in, get them in. We're not going to have an after party today because your boy's got a jet, but we'll make sure we get your comments. Now, let's see who's joining us on the day today. See if we got a couple of comments here. We do. Yeah, we had a great question this morning about sex offenders from the members only stream this morning. Great question. Hey, happy Thursday. Look at this very pleasant cartoon cat. Bonnie is here. Hey, we got a win here out of NPR. Supreme Court allows Trump to prohibit gender elections on passports. Really? I didn't see that. So Bonnie, thanks for that one. Yeah, very interesting. Okay. So did they reject an appeal? Something like that? Like Trump made the rule change, somebody filed. Did they issue a decision today, or did they just reject a petition? Thank you, Bonnie. Win, indeed. Yeah. You don't get to do, expialidocious on your passports, okay? It's pretty simple. Pick one. Hey, Tasadaka. Hey, Rob. Hey, I hope you don't mind me sharing this. Send go for my husband's cancer treatment. Man, I would appreciate all your thoughts and prayers. So yeah, no, I don't mind at all, Tasadaka. I'm so sorry to hear about your husband's cancer. And we hope that you get all the support you need. It's at givesendgo.com/prayer4pops if you care to help our friend Tasadaka and her husband. Cancer sucks, man. My mom's a multiple cancer survivor. And it's kind of something that runs in our family, allegedly, I guess is how it works. So cancer sucks, man. Tasadaka, praying for your husband for a speedy healing. And my friends, there's the link, givesendgo.com/prayer4pops. Helping Ben. Is that Ben? Man, what a handsome dude, Ben. Sorry to hear about the cancer, man. Spuds is here. Hey, just a brief shout out and shameless plug for the Rubos. I received their, hey, you did, Spud? Spuds, we had steaks last night, and Alexis prepared them with the Rubo salt. It was very good. And she's like, you know what's on these steaks? I said, what? She said, it's Rubo salt. I said, I knew it. I said, you know what it's from? The oceans of France. That's why the steak's so good. I received their Rob and Alexis limited time discounted 2 salt pack special. It came with a nice personalized handwritten note and professionally wrapped packets. The Rubos are great. I felt bad opening one of them because they look so good. I'm not kidding you. It's really good salt. It comes from the ocean of France. It's, I don't know what you're already using. If it's Morton's, time to class that up a bit. WTW35 at rubosaltshop.com. They're amazing. And we appreciate you guys supporting the Rubos. They have great prayers, very good people, been around for a long time. We love them. Hey, thank you to the Rubos. And thank you, Spuds. You now have some of the best salt on the planet for your taste buds delight. We got this one from RP Games. What's up, RP Games? We got 10 new membos coming in. What's up? Welcome to Miss Vicky May in the house. Betsy Ross is joining us. We got G Lane, Blondie D, Clay Napier, Bo Hunter. What's up, Mike Salter? Bridget Nepper, Jana Queen, CGI Joe, all gifted membos, courtesy of the RP Games in the house. Thank you, the RP Games. Welcome, new membos. Grab the members only stream from this morning. FD man. Able and experienced DC judge means, hey, idiot, fix this problem. You done goofed up the floor. Okay, we'll fast forward through that one. Chubby's here. I feel like this vacate order is like the old Tootsie Roll commercials. How many blatantly flagrant errors can a judge make before they get in serious trouble? Just keep licking and licking and licking. I guess that's more wordy than how many licks does it take to reach the center? Yeah. How many licks of a judge's forehead does it take to get some intelligence? A lot. A lot of licking. No intelligence will come out. FD man, joke of the day, says, I was playing with my son when he was very little by tickling his feet. My wife said, stop that. Wait until he's born. Oh. FD man, Rick D, what's up? Federal prosecutors have opened a corruption investigation into Democrat D.C. Mayor Muriel Bowser following a trip paid for by Qatar. Oh, no. They're everywhere. Okay, that's funny. Yeah, that's interesting. So Muriel Bowser, she's also on the list out there in D.C., huh? Very, very interesting. Federal prosecutors. I also saw John Brennan is probably getting some subpoenas, too. Hopefully that drops tomorrow. New indictment Friday would be great. Jedi Trump. These are not the illegals you're looking for. We got Liz B. What's up? Whistle Stop Cafe. Letty's here. Karen FC Sap in the house. Aaron Toyer. All gifted membos courtesy of Jedi Trump in the house. Good to see you, Jedi Trump. Welcome aboard to our new membo friends. And a couple other comments. 127 Gold. Yeah, that's great. Sounds like the prosecutor was protecting the furry trans community. Is that maybe that's what it is? Like, I don't want to offend our furry friends. Time to see the trans brainwashing pipeline. Great show, Rob, and congratulations. Hey, thank you for that. I think 127 Gold on the marriage or just completing the show. Either way, we appreciate it. Yeah, and we want to see everything in this trial. And the more they lock it down and the more they file stuff under private seal, the less credibility we're going to get it. I don't know why they're doing that. They haven't done that historically. So something feels off. Hey, Rob. Kylis Rex in the house. Hey, Rob, how has she seen, talking about Erica, what the case is built on? If you were the defense, wouldn't you be asking the judge what she has seen that hasn't been made public? She wasn't a witness. No, I would say, though, she's a victim, and she's, I think she might actually be considered a witness based on the fact that she got the immediate phone call and received information. And if you think it's a bigger plot outside of Tyler Robinson, then I would say she's probably got some pretty good, keen insight into that. So I think that she could be a witness, but she's also a victim. And I'm sure that the prosecutors are working with her and communicating with her on the status of the case. You know, she would be around, like, let's say for at sentencing, right? For a victim impact statement. You took my husband, you took my daughter's father, all those things. So she'll be close to the case. In many prosecutions, they actually have like victim services that will work with these people who are part of the government. But I would imagine that she's got, inside information just as the status of a victim. And I don't know Utah, but many states also have victims' bill of rights that that are codified that say victims are entitled to certain information about the prosecution. They're not just kept completely in the dark where, they're like walking around every day with no idea is this guy released? Is he going to come, attack us or whatever? So they're kind of brought along. And I think she said she's seen some things like the autopsy and other things. And there are some of those other things I've got questions about. And I think just because it's not mandatory that she gets information doesn't mean it's not discretionary that she gets information. But I don't really know. And if I were the defense arguing that she got information, I think, how would that prejudice your client? Like, does it jeopardize your client if she's got information? Like, the information I don't think is a problem. Let's say, for example, if she came out and she started talking about non-public information and revealing things, then maybe the remedy for Tyler Robinson would be gag her. Okay, she can't talk about those things because we don't have the, she might be prejudicing the jury or whatever. But it would be about not giving her the information is not really where the problem would be. It would be about her disseminating information that she shouldn't be disseminating. So, yeah. And if she was brought in to testify, for example, like could she have a conflict of interest? Let's say that Tyler Robinson is on trial and you've got multiple victims in the courtroom. You would have a rule to preclude the victims or the witnesses from hearing what other people testify. And then you would just cross-examine her about her role in the investigation. Oh, did you meet with prosecutors? Yeah. Did you meet with the case investigator? Yeah. And you could just, any problems with that access could be addressed to impeach her or to undermine her credibility at the trial as a defense attorney. Oh, so you got this info. And so did they program you to think that, or did you volunteer that to them, or did they volunteer that to you? When did that happen? Okay. So you read the report and then your opinion changed and then you came out and said this, right? So the timeline's a little bit off, and kind of go into him, in that regard, if she were testifying for whatever reason. I don't think she is, but you could also argue as she was like, she got spontaneous information. As soon as she got that phone call from the chief of staff, he calls her. She's got, spontaneous utterances coming out of his mouth constantly about what happened. What did he see? This is what I heard. This is what I directed to happen after that. So, yeah, but we're all waiting for some actual information, and we didn't get any of that really from Erica, nor should we expect to, but we'd like to have the prosecution open and transparent so that we can actually see what's going on. Thank you for the great question, Kylos Rex in the house. Will Crump, will the mere process of Boasberg impeachment be a warning shot to all other inferior Article 3 district trial court judges? I sure hope so, yeah. I think if they recognize that Congress is willing to stop playing games and start impeaching judges, which is one of our biggest criticisms of Congress. It's like, what are they doing? All they've done is pass like one big, beautiful bill. Otherwise, they're just spinning their wheels, and they haven't codified any tariffs. They haven't done anything to codify the border changes. They haven't cut spending in any way, shape, or form at all. And they're not impeaching the judges. They're not exercising proper oversight over the DOJ, over the FBI, creating their own January 6th select committee that's actually real, stuff like that. Simultaneous with that, they're also not impeaching anybody, which is their constitutional duty. They're falling on their duty, and they're losing at the polls. The Chugi Show. Yeah, making yes, I want it public. I don't find it helpful to compare Rittenhouse or Trump. Different courts, very different cases. Yeah, definitely different courts, like they're not in Utah, but they're high-profile defendants. Very different cases. Doing things via Zoom is not a big deal. So respectfully, the Chugi Show, I completely disagree. I mean, I think that you should have, in Arizona, like our felonies, you're in person. Your defendants are not calling in. Everybody's coming to court, and you show up. They're felony charges. It's an assassination case. It's not a misdemeanor. It's not urinating in public. It's not misdemeanor domestic violence. It's a major, massive felony of national importance. And the different courts thing is okay, that's fine, but they're all state courts, right? So Alvin Bragg, we had Fannie Willis. They didn't bend over backwards to protect Trump. He's a defendant. We got to see the publicity around those defendants. And I think in many cases, the media coverage was to hurt those defendants. Okay, the media came out specifically to ridicule Kyle Rittenhouse, to destroy Derek Chauvin as the white murderer. So the media coverage was damaging. And now that they're not enabling media coverage, what can one conclude? Almost as though that decision is meant to help the defendant. So why do some defendants on one side of the political aisle, like Trump, Chauvin, Rittenhouse, get just castigated in the media and everybody can write articles about it, whatever, judges don't care. But when it's a furry murderer of conservatives, now even our prosecutors are bending over backwards, and they're all state courts. Chauvin was prosecuted in state courts. Trump was in the middle of running for president, and they've spread his mugshot everywhere. They didn't care about what that did to him at all, or how that impacted or prejudiced anybody. So why is media coverage used as an attack vector on one and then being protected in another one? Chauvin was state, Fannie was state, Alvin Bragg was state. That's my point. And things via Zoom, I mean, if it's like a very small, meaningless hearing, that's fine. They want it for the rest of the case, basically. The reason they want the Zoom is so you can't see Tyler Robinson. That's the point. It is a big deal when they're trying to cover up access. So anyways, the Chugi Show, thanks for respectfully disagreeing. I appreciate you being here, and thanks for the dono. The Ribos. Rob, we're putting the finishing touches on a powerful prayer coming against cancer. We will share it with you and the Watcher family as soon as we can. Enough is enough. We rebuke cancer. The master prayer for dismantling the strongholds of cancer, all forms, stages, and metastases of cancer. Man, that's going to be a great prayer. Yeah, we may have to read that one live. Darla Shumate, Senate Republicans crush the Dems in their desperate bid to hand off Trump's crackdown on Venezuela narco-terrorists. Resolution is dead on arrival. 48-51. Senate Republicans crushing the Dems' desperate bid to handcuff Trump's crackdown on Venezuela. Interesting. Interesting news, Darla. Yeah, so the Senate still not doing much of anything today, it sounds like. But that's a good one. If they're not going to do anything, at least they're not doing anything on that. All right, so my friends, thank you for all those donos. Thank you for being here. Thanks for the great love. Welcome to our new members. We got a couple comments on X before we wrap it up on the day. Neuro D, hey, give Rob a follow over on Rumble and say hello in the Rumble live chat, baby. Yes, indeed. Donuts over there. Kids today. Jacob Castro, what's up, Marley? We got Dog Digger in the house. Lil Galaxy in the house. Hyphen, what's up? Great to see our friends on the Rumbles and over on X. We had this one from Satellite Boy. Says, if Michael Cohen getting David Pecker to kill the story was election interference, then Anthony Blinken getting 51 Intel officials to kill the Hunter story is also election interference. Yeah. When does Joe Biden's trial start? Got to ask Pam Bondi. She probably just left the P.O. box. She was just sending letters over to Congress, hoping that they can do something like prosecute somebody, I guess. All right. And so, my friends, thank you for those. Let's say hello to our friends on Locals, and then we'll wrap it up on the day. And, of course, be back tomorrow. Hey, look at this. Yeah, here's what it looks like. From Spuds, salt delivery. Note the fancy packaging. Yeah, this is how we get it too, man. The Rubos put a lot of detail into their everything. So they're amazing. That's what it looks like when you get it. And that's the salt, baby. And you flip it over, and you'll see it's from the ocean of France, man. It's good salt. Tastes good on a filet. And Elliot says, humbled brag, rather than humble brag. Yeah, he definitely did get humbled. No doubt about it. So, good stuff over on Locals. And my friends, really great to have you here. Thank you for all the donos. Thank you for the support and for joining us. One more reminder, if you haven't subscribed already, we'd very much appreciate if you did that so that we never miss you again. And thanks for hitting the like button too. I know we're asking for a lot, but also share the show with everyone you've ever met in your entire life. And we'll leave it there on the day. We appreciate you joining us today. We're coming back tomorrow. It's going to be a Friday. We're excited about that because we'll have business to attend to and we're not done yet. Before we wrap it up today, big thanks to our mods and meme smiths. Thank you very much to Donut Mind Me. We got John in the house. Carrie B, K Bean, modding the fort down for us, Muffin Rando, Neuro D, Janek, Dog Digger, all over on the Rumbles, helping out. Gigum Giga, Mod Smith, Meme Smith extraordinaire, Elliot, and Just Rhonda, all modding the fort down for us, keeping things nice and beautiful around here, my friends. It has been a lovely stream. I hope that your rest tonight is absolutely outstanding. You have the most peaceful, pleasant, and beautiful dreams bouncing around in your brilliant brains. You rest well. And you join us right back here tomorrow to get into it again, because in order to do that appropriately, we are going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Outro song is incoming, but no Membo stream. We'll see you back here tomorrow, my friends. Make it a great night. Be well, and bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers, truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide, fighting for freedom with nothing to hide. So drop a like and don't forget to share, and bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together